Survivor, we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, SGS Nation? Welcome to Surviving the Survivor. It is the show that brings you the very best guests in all of true crime on trending criminal cases, and this is one that's been trending way too long. It is going to continue to trend because the trial of Donna Adelson just got pushed back, and as a result, the Markel family must endure more agony, more heartbreak, and more pain as they sit here and wait for yet another murder trial after the conviction of their ex-son-in-law / brother-in-law, who is Charlie Adelson, convicted in this murder for hire plot. And he is now spending his days rotting away in South Dakota so that the Latin King gang members do not get to him. I want to keep getting some perspective on all this. Plus, we've got a new bit of news regarding the trial date here. To give us their fresh opinions, we've got, and she joined us earlier, Dr. Melissa Hamilton with a very interesting background. She is a former corrections officer in the great state of Florida, a former police officer, and now a professor of law in the UK at Surrey in the UK. So welcome to Dr. Hamilton. And then we've got Jeremy Mutz, who is a former prosecutor in this very county, Leon County. He is now a criminal defense attorney and once again is a brand new father to a baby boy. What is the baby's name, Jeremy? And as they say here in Miami, Mazel Tov. How's everything?
Well, thank you, Joel. Thank you for having me on. He's really a joy. His name is Levi, and we're really enjoying him. It's a challenge, a lot of changes because we're kind of old parents, quote unquote. So we're getting used to it.
Well, welcome to the club. I'm pretty much as old as I can get, at least for a 5-year-old. And we're going to keep this to about an hour today. Just get some new perspective. Professor Patuto is joining us, and the main reason I am leaving early is priorities. The Los Angeles Dodgers. My son was born in Los Angeles. My wife is from Los Angeles. They are in town playing the Marlins, and my son is a T-ball addict, so I'm going to take him to the game right after this. There you go, Spaced. And we will get you and, not you, Mutz, but you, Space Coast, maybe Mutz, and my son a Shohei Ohtani autograph. I'm sure there'll be no one else there. He's only the greatest player of our generation. Anyway, so the obvious headline here, and there's been a lot of headlines in the last couple of weeks, but the newest headline is now a new trial date has been set. Now, originally, jury selection was set to start June 3rd, which is less than a month away. The trial has now been pushed to August 19th. And Jeremy, this is in part because of a massive discovery dump by the state of what is said to be 100,000 emails, but could be other pieces of digital forensic evidence. Your reaction to the this massive dump so close to the trial and the new date that we've got coming up here?
Sure. Well, thank you for having me on, Joel, and it's an honor to be on with Dr. Hamilton. I'm not really surprised that there'd be a delay. I'm also not surprised there'd be more evidence because over the last year, 18 months, we've heard reports of 8 CDs of discovery, 55,000 emails and things like that. So I'm not surprised there'd be more. I sort of had the inkling that something more was coming with wiretaps and things like that. So I'm just not surprised. I mean, I feel like the case is going to be stronger. And for that reason, I am happy, for the effort to secure justice for Dan Markel, that this case is going to be stronger against Donna. And it may also indicate, I think I listened to a good portion of the program you did a day or two ago with Mr. Baptiste and everybody on, indicating to me from what y'all were saying, this may indicate more charges are coming, maybe against Wendy, because there are a lot of wiretaps out there. If the state's only going to use a couple in this one, to me, it suggests that there's more that may shore up the missing evidence that we've thought would be there. With Wendy, Donna just can't help herself. I mean, I think it shows that, and then anytime as a defense, you start listing witnesses in the jail saying they're going to provide, this great defense for you, you're kind of poking the bear with the state, and they're going to go in and find out, okay, well, what kind of money are you funneling to these inmates to say things that are going to help you out? So I think some of that is that, you start doing that, the state's going to just put the spotlight back on you. So I'm not really that surprised.
Yeah. By the way, I'm terrible with family dynamics. Never got any of this stuff. I guess I'm just slow, but you're right. Charlie was, you get what I'm saying though. Charlie is Wendy's brother. You get the idea. Jeremy, this is another interesting question. Then we'll get to Dr. Hamilton, Dr. Reinhardt in the chat quite often. I have never heard this, but has anyone else heard that the prosecutors have polled or interviewed jurors on previous trials who say they thought Wendy was guilty and would have voted to convict her? Rumor or true? Is that something that is allowed? I've never even heard of that. This is basically, had they asked previous jurors or polled them about Wendy's culpability and all this? Is that something that they could even do if they wanted to do, I guess?
That's a very interesting question. By rule in Florida, neither side can contact the jurors, but if the jurors want to talk to either party, they can. They're free to do that. And I know there have been some jurors in this case, the first Katie Magmanua trial, that some of the jurors went and talked to media, but they have the absolute right to maintain their anonymity, and neither side can do that. It's very interesting, though. I think that would be very interesting to see what they felt in past cases or the grand jury. And I don't know if you remember Preston Scott. He was on a grand jury at one point in Leon County, and he felt like the evidence was really there for Wendy for all of this. And he's a media figure. He gave his feedback, but normally that's not an insight that we would get. And it's something
I'm sorry, was that a grand jury related to this case for Preston?
That's my recollection of it, that he said that to me. I think he said it on the air as well on a couple of occasions that he happened to be on one. It'd be interesting to clarify with him, but that is my recollection of that.
All right. We're Joe Patuto, the COE is now having a heart attack. You are much too beautiful with your flowers and that pretty face to have. You have a big smudge mark on your computer. So you and you're muted, but you're gonna have to. Can you get like a little tissue and wipe your camera lens? It will bring the COE inner peace if you're able to do that.
It's not that, because I tried it earlier. I don't know what's doing it, but it isn't smudge or whatever. So
it might be the holiness that surrounds you, Joe. That's maybe what it is.
That's absolutely what it is. Clearly.
On the day that the conclave is starting, you're in Italy. That's exactly what it is. That's my bet. I hope it's not smoke.
I'm in New Jersey, so
yeah. If it's smoke from the conclave, we've got a much bigger story here. Dr. Hamilton. So the obvious headline, and by the way, we're going to keep this footloose and fancy free today. So a lot of questions from STS. Please put in the triple Qs. I will keep scrolling down to the bottom to get them to our esteemed panel. But Dr. Hamilton, you just heard Mutz, and we'll get into this. Jeremy Mutz, get into this. We'll get into it more, but the implication is maybe there's something on somebody else, which we will look at this already. Look, I bet you that the COE already probably DM'd Joe immediately about that, because the COE does not like smudge marks. Anyway, Dr. Hamilton, the new trial date is set. That's the headline. It is now August 19th instead of June 3rd. It's upsetting. It's particularly upsetting to the Markels. I know that. But as Jeremy said, is it a surprise to you at all?
Not a surprise, just because there have been changes of council which have delayed things, and we've seen many signs of this new council wanting to delay as much as they possibly can. So that seems to be consistent. At the same time, playing devil's advocate for them is, if they did get this treasure trove of lots of additional information along with everything else they're doing, I can imagine it's hard to tackle all of it. At the same time, at the hearing, the prosecution did concede that a delay would not prejudice their case. And so the judge being measured and wanting to be fair for everyone, that was then at that point, I thought he's going to grant the delay because on balance, prosecution's not prejudiced, the defense is asking for it. That just reduces the likelihood of a good appellate case in terms of that. So that was a relatively easy grant considering those circumstances.
I guess it's all half glass, half full or empty. Tay says all she can focus now on is Joe Patuto's blur because of her ADD. But is it really ADD, or are you just able to focus so well that you are just simply focused on the smudge? It's kind of, by the way, it's getting smaller and smaller. Joe Patuto, yeah, Joe, am I crazy, or were your flowers on the other side 10 seconds ago?
Well, I don't know. I've been moving and moving to see if I can. It must be the sunlight, and I don't know what to do about that.
Yeah, there's nothing you can do about the sunlight. That is for sure. Before we dig into like the particulars, Joe Patuto, for those who do not know, Joe is professor emerita at the University of Nebraska Law School, but that would be like me giving you guys a bio for Oprah. You know who she is. So, Joe Patuto, just your opening comments here. It's been a couple days since we've had you on. You've been on top of this. The obvious headline again, the trial date now pushed to August 19th. But your opening thoughts before we dig in here, and we're going to get to that COE in a second.
Yeah, I was, as I think probably most of the people on the chat were, and certainly the Markels, frustrated that there's another delay. But I've been thinking about it over the last couple of days. And, people who wanted Donna to be prosecuted with Charlie, had that happened, the evidence of her trying to flee the country and go to Vietnam where there was no extradition and buying that one-way ticket, which may be the most powerful evidence against her in this trial, that evidence would never have been created, would never have happened. And if the trial had gone in September, then Sarah Youssef coming forward and talking to the Markels and then being put in touch with the prosecution would not have occurred in time. And whatever the evidence that's coming from the wiretap, which may be, somebody who was in jail and is now released, it theoretically could be Harvey, whatever that evidence is, also would not have been created. We wouldn't have it. So I've been thinking that with all the frustration about the delays, in fact, the case against Donna has gotten much stronger. And that on balance is a pretty good, quid for pro for quid, or however you do it.
Quid pro quo, but yes.
Yeah.
God, I love being able to correct a professor. Please make more mistakes, Joe. Vesper Martini here. Interesting question. So, Jeremy, I'm not sure if you caught the last hearing, and Judge Stephen Everett. For those who are just joining, Jeremy was a prosecutor in Leon County. He seemed ticked off, as my dad would say. Kind of that's an underused expression, by the way. Vesper Martini here saying, I won't be surprised if there would be another delay. I think Judge Stephen Everett, you'll see smoke coming not out of the conclave, but out of Judge Everett's ears.
Sure.
What are the chances that this gets continued again? It seems to me, and this is a humble opinion, that Josh Zellman and Jackie Fulford are up to their eyeballs just in stress and discovery, and maybe they'll make a play to delay it longer. What do you think Judge Everett's reaction would be?
Well, understandably, he's frustrated that the case, he feels like he has one set of facts that are going to go to trial on a schedule, and then he finds out there's a lot more evidence, and he is compelled. If you deny the defense adequate time to prepare, then you're looking at an ineffective assistance of counsel later, and all the hard work that goes into a trial. And you could try the case perfectly, but then they can still raise ineffective assistance at the end of it because they don't have enough time. And he knows that. He's very intelligent. And nobody wants delays. So I think he's understandably a little frustrated there. But I think the chances are probably high that it gets delayed further. I mean, just the sheer volume of evidence, the typical felony that goes to trial in Tallahassee, in Florida, typical case, maybe there's 5-10 witnesses, maybe there's on the high end, there's 100 pieces of evidence. But here's a case with, we're talking 50,000, emails. We're talking about, reams of evidence. Now, can they be ready in the time frame that we're looking at? Sure. Mr. Zellman, he's, got a lot of experience. Jackie Fulford's got a lot of experience. They have some staff members that are going through this evidence. They're using AI, which, think of that. We wouldn't even be talking about that 5 or 10 years ago, but he's using AI to sift through this. So they could do it, but I would not be real surprised if it got delayed, one more time subsequent to this.
Yeah, we'll get into the AI. But yeah, 5-10 years, we might not be talking about if it was 6 months ago or a year ago with AI. It's that new. So, but yeah, they're using a program apparently to sift through it. Now, this is a document from the court here, and you'll see on Wednesday, April 30th, the court held a hearing on the defendant's expedited motion to continue the trial. Based on the continuance, the court sets the following discovery date. So discovery, and by the way, there is a hearing this Friday. We're going to take it live at 9 a.m. Donna is expected to appear via Zoom. It's not 100% clear the details of this hearing, but we will be there for it and try to bring it to you live. And by the way, those who joined earlier on Shanna Gardner, the hearing eventually happened, and it was a 9-minute long hearing, and the COE is going to post it under, I believe, the video tab, but she will let you all know. But Dr. Hamilton, kind of break this up. You can see the discovery deadline now is on or before Friday, May 30th. Pretrial motion filing deadline, Friday, May 30th, 2025. Witness list, exhibit list, and demonstrative exhibits, May 30th. And then there's a final page here, case management hearing, which I guess could be somewhat lengthy, is going to be on June 11th. So mark your calendars. But I personally don't think Judge Everett is messing around. It's an easy thing to remember because he set everything for May 30th, 2025, the discovery, the pretrial motion, the witness list. But I mean, how, I guess, set in stone is this document that we're looking at right now?
Well, I think at this point, this judge has not indicated he would never entertain another one, but I think it's going to be a significant hurdle to convince him to delay it again. But as this case has progressed, we've had surprises. So you never know what's going to come up, whether there might be something that is sufficient to convince them to delay it a little bit more. But really what the defense attorneys did here is they really rolled the dice at not getting in trouble for failing to meet the deadline, because basically what they seem to argue to the judge is, we simply didn't get to do the things we needed to meet your deadline because we thought something else was more important. And again, this being an important high-profile case, we're watching it live, the media, the judge really does not want anything to be overturned. So he was giving them the benefit of the doubt, but that was a risk that they took, that they wouldn't be chastised for purposely not meeting the deadlines.
Just looking at some of the comments, and please say it's not so, but they're discussing rhubarb again in the chat, which happened a couple of months ago, and it was an intense discussion. So I don't want anyone getting hurt over a rhubarb controversy. But Joe Patuto, to you, I mean, does anything here on this document from the court stand out? The obvious, it's pretty straightforward. I mean, you got a discovery deadline, a pretrial motion filing, this witness exhibit list. I guess my question, if nothing stands out, is what are you expecting on Friday? We just had this hearing last week. Here we go. Vesper Martini knows all. Don't let the mask let you think otherwise. She is fully aware of what's going on here. The defendant's motion to take additional depositions since they won't make court deadlines. That's what I thought it was. It's going to be, Joe, more depositions. Joe Patuto, who else could they be looking to depose right now? Now with the trial set for August 19th.
Yeah, we don't know what information is on the new wiretaps, or what information Sarah Youssef may have provided, or any information that they have now been able to develop based on the wiretap information or Sarah Youssef. So there may be other witnesses there. I also think there's some witnesses that they didn't get to deposing that were on the original witness list that they're now seeking to depose, and doing it by Zoom, which would I assume be more convenient to them and maybe more easily scheduled. So the ones we don't know about, we don't know about. The ones that they list on their witness list or suggested that they were going to have appear, or where we had information from them that they were going to depose, maybe some of the ones that are now in their list to get done. But I do agree with Melissa that if the new information was so substantial that the defense lawyers couldn't meet the original discovery date, their failure to get in touch with the judge and the prosecutor and alert them to it seems to me to be, it wouldn't be the way I would want to proceed with a judge who was going to preside over the trial, because it wouldn't hurt to just say, hey, all this stuff came in, we're trying to balance everything, and it looks as though we can't get to the discovery date that originally we thought we were going to meet, and just put the judge in the frame much earlier, and also just have him be able to, as you go forward, agree, rather than just spring it on him at that hearing. I just don't think that's the best way to proceed to trial in front of the judge who's going to be hearing the trial. And I never understand when lawyers do this, because it wouldn't hurt to do it the other way.
Yeah, that's a great point. This is a good question to Jeremy. Jeremy's kind of got an inside track in Tallahassee because he was a prosecutor there, but Cooler by the Lake. What happens if additional discovery is unearthed after the May 30th deadline? Great question. And the way things are going, that seems like a possibility. So what would happen, Jeremy?
Well, it really kind of piggybacks on what Professor Patuto was saying, in the sense that, if that happens, woe betide the party that doesn't give the judge a heads up and say, Judge, this just came up, and try to deal with it, well before that June 11th case management. Don't just walk into that case management and say, we've got something new, we need another continuance. Immediately you get in front of the judge. And I think Judge Everett is very patient with what's happened so far. And I think he probably understands that it's not just purely a matter of the defense choosing to put their time in one area and not doing the other. I think he knows the volume of this. I think he read between the lines, and that's why he gave every indulgence and every courtesy to the defense. And he knows also if he denies a continuance and just presses to trial, they're not going to be ready for trial. But now I think we're coming up to this new deadline, a new case management. They're going to have to just keep the judge informed if something really comes up. And it could, the state may get new wiretaps that they just really have to consider using and have to disclose. There may be some new exculpatory evidence. There could be a number of things that could trigger that. The defense may have a legitimate reason to want to continue it and extend the discovery deadlines. They just need to keep the judge informed. Leon County is a little bit laid back. It's a little bit more informal. I've practiced in federal court, and you really don't want to start pushing the envelope with the deadlines in front of a federal judge. Judge Everett, though, it's getting to that point that deadlines are going to have to mean something. So they're really going to have to show something significant to keep pushing it back.
Yeah, speaking of federal judges, I am planning to go up to New York on Sunday for opening statements in Diddy. I'll be there for as long as I can make it. Probably not the full 8 weeks because I have 3 kids and we'll get served papers, which I can't really afford or want to happen right now. But I'll be up there for a little while and maybe go back up if need be. This trial obviously is going to happen a week after Brian Kohberger's opening statements happen. Jury selection in Brian Kohberger is set for July 31st. I have travel already booked for Brian Kohberger, so I'm still planning to be out there for opening statements on Brian Kohberger, which in my opinion will be the biggest trial of the year. Don't let Karen Reed people tell you otherwise. And yeah, and then we've got right now tentatively scheduled, we've got Stefan Stern. So Jeremy, I just want to come back to you on one other thing, well, a lot of other things, but right now, and then I'll get to this question on the screen, but there was an effort to have Judge Stephen Everett recused, and I don't know where, because I'm a little foggy at the moment, but then I heard that they might make another attempt potentially, and this was, I think, a second attempt already. How dicey is it to try to get the judge who's presiding over your case removed from your case, especially when he was like, yeah, there's no legal, there's no legal standing for this. What's going on there?
Well, I think it could be, if you look at it sort of on the looser end of ethics, it's just another tactic. It's just another way to try to delay the case and to muddy the waters and block the case going to trial. And also it's another ground for appeal later on if you want to be on the cynical end of the spectrum. I guess that's what I'm saying. Now, if you have a legitimate reason for it, then it's something you do. I don't know that most judges are not going to take it personally, but like anything else, the additive effect, if I'm a judge and having to deal with all kinds of motions that I feel like are frivolous or just delay tactics or just trying to, sow the seeds for subsequent appeals, I kind of get irritated with that. But yeah. Judge Everett's very professional. He's certainly not going to let that sway him one way or another. But as a practitioner, I'm certainly going to be aware of that. I don't want to file things that lose credibility for me. That's number one. My reputation, I always want to file something that if I feel like it's ethically supported. But that compass is a little different for each attorney. Some may feel like this is just something I have to do for my client. And a lot of this is just transactional. The motions get filed and it's not taken personally. And motions to recuse are not totally uncommon. I've had clients that will do that pro se. I've had, I've seen multiple times where attorneys feel they need to file it.
Yeah. By the way, tomorrow night we're back with Brian Kohberger shows. Interesting news in the last couple of days by a person we've had on the show, kind of a controversial journalist named Howard Blum, who wrote a piece basically saying that the motive or a part of the motive for Brian Kohberger, who is accused of this, is to try to impress his criminology professor at DeSales, a woman named Dr. Catherine Ramsland, who coincidentally wrote a book with the BTK serial killer. And it gets more and more interesting. So we're going to do a show regarding that tomorrow. On to this question to Dr. Hamilton from Zach Sawyer. I heard Wendy put her condo in a trust back in October, and shout out to Fancy Fiction, one of the OGs, if not the OG on this case, who put that out there. Isn't that about the same time that the state applied for the new wiretap? What do you make of this, if anything, Dr. Hamilton? And Joe, I'll have you weigh in on this as well, that apparently something goes into a trust in October, wiretaps are out. Is there any there?
Very possible, because it could, of course, be totally coincidental, but then why had she not put in a trust at any time beforehand? So that might well be a link. I think that's a really good theory. So one of the suggestions is that the wiretaps are around some evidence of witness tampering. Maybe so, possibly plausible. Sure.
Joe Patuto, your thoughts on Wendy putting her property into a trust right around the time the wiretaps or a search warrant is executed for the wiretaps? Is it just serendipity, or is there more there?
Don't know, but I suspect it's serendipity. the putting things in a trust, there are tax reasons for doing it. Why she waited, who knows? And I suppose it's theoretically possible that it has something to do with what happened in October. But of course, for that to be true, she'd had to be in the know that something was going on in October. And it's not clear to me at all that anybody on the defense side knew that. So there's no reason to believe that Wendy would, unless she's in touch with the potential informer who against whom the investigation went, or Harvey told her something. But I think on balance, the likelihood is that it's not cause and effect. It's more two things happening at the same time.
Yeah. Jeremy, to you, here's a question from President Gerard, not to be confused with Gerald, who's Ford. Joel, isn't it the case? I once asked Gerald Ford for a photo. I met him in like the 90s at an event, and I asked him for a picture, and he goes, "You sure you want your camera lens to crack?" I had like a disposable camera at the time. Joel, isn't it the case that this defense team will also be tainted if Dan Rashbaum is referenced in the new emails and any conviction is unlikely to be overturned on appeal? What about the name that won't go away, which is Dan Rashbaum? What if this comes up?
Well, I don't think so. I'd kind of like to know specifically what President Gerard is thinking, what his thought is on that. But I kind of feel like if anybody looks bad, it would be potentially Mr. Rashbaum, because you're looking at emails of what Donna is saying to him back and forth, and these are a new set of attorneys that are not affiliated with him. I don't think that would be the case, but I'd be curious to see what he's thinking about it.
Yeah, and Jeremy, right back to you. So we know that there are 32 new hours of wiretaps, to which Sarah Catherine Dugan basically said that they're only going to probably use a 1 or 2 calls for this trial, and that there's an active investigation that was opened in the fall. What is going on behind those closed doors at the state attorney's office? Take us kind of inside baseball, as I like to say. You've been there. What are you reading between the tea leaves here?
Well, they're actively preparing this for trial, as they have on the other cases successfully. It's a lot of work behind the scenes. They're going to make sure they have everything disclosed in discovery. And a lot of things are just mundane. There's certainly strategizing. Certainly the strategizing that would go into the new evidence with the wiretaps. They've gleaned through that. They've narrowed it down to the ones they feel like helps prove the case against Donna, the consciousness of guilt that would be, circumstantial evidence, also direct evidence that if she's talking about the case, if she is in an effort to influence other witnesses and to procure their testimony through financial incentive. All of those things would be direct evidence. So they're building that out. And it's just something that, if you've ever seen movies where somebody's preparing a big case for trial, it's a lot like that. It's very intense. You're putting a lot of time in on that. Of course, unfortunately, though, these prosecutors have other cases as well, other homicides, other serious cases. So they're still going to court on those. They're still probably going out to the law enforcement agencies to look at evidence. They're probably doing some of that in this case, even though they've been through it before. But you're just constantly adding to it every single day. You're working, hours and hours to make sure you're presenting the best case you can.
Yeah, I have to agree with this. Jeremy's voice is like butter, even though she's a Texan, Ned Smith. Joe Patuto, you were here on the show where Tim Jansen said this a couple of shows ago that, and Tim knows a lot of people. He's been in Tallahassee 40 years. He essentially said that Tim has always been kind of not on the Wendy being indicted train, but the last show he was on, he said, and I think I quote, the tenor has changed, that he talked to people and the tenor has changed. So how do you read that other than they've got the goods on Wendy? Is that what is to be read into this, or could it be something more subtle and sublime than that?
maybe subtle, but not sublime. I doubt that anyone on the prosecution side is telling Tim directly information related to the prosecution. But I also think it's more than possible that Tim, in his interactions with them, can detect a different level of maybe excitement, something in the tone, something in what's not said, something that's said that's not direct, that leads him to believe that the prosecution now feels more confident in making a case against Wendy. Now, I don't know that it would be, gee, they've got the smoking gun now. On my guess, if I'm guessing about this, is the cases are circumstantial cases by and large. And so every new bit of information that helps build a circumstantial case moves to the critical point where the prosecution thinks in good faith they have enough to proceed with the prosecution, and they have a reasonable basis for thinking they can get a conviction beyond a reasonable doubt. So I think you'd have to ask Tim this directly if he would be willing to share, but I think what he's indicating is a sense from the people he talks to that their view has changed, and they are conveying that not by saying anything directly, but in body language and excitement, in pauses and what they're saying and what they're not saying.
Yeah, I think you're onto it there. I haven't completely confirmed that with Tim, but I get a feeling it's more of the way things were discussed or not discussed and kind of the energy when he spoke to these people. So thank you to Deb for the super chat, and Marcia as well. Can Vesper be a guest? I'm more intrigued than you, Ned. I would love to have her on. She actually lives in my city, her city. But yeah, I kind of like the mysterious aspect, so we'll keep it that way for now. Dr. Hamilton, I'm coming back to you in a second, but again, Jeremy was inside this office. So this discovery dump, speaking of Tim, he had told us leading up to this that it was 85,000 emails, and then we hear the number 100,000, which is a huge amount, any which way you slice it. What are your best guesses, Jeremy, as to why so many emails so close to the trial date? We know that they got devices from Donna and I believe Harvey. So does this mean that, I don't know, in the last few weeks, they were able to crack the proverbial code? What else could this be besides that?
Well, that might be it. They might be in a position they gained access to one of these devices. It could simply just be the volume of evidence and newer search warrants that are returning evidence that it's coming in as quickly as they can process through it. I mean, I think Donna's interactions with inmates at the jail that could potentially be witnesses either for her or against her. You've got new content then that's being created with new jail calls, new emails and stuff of that nature. And it's just a matter of the time it takes to go through it and say, okay, this is evidence and we have to disclose it. And it's something we're going to use. We're going to disclose it. So I think it's part of that. I don't know that any of it's something that's been sitting there. I think it's stuff that's developed, in the course of the last several months.
Yeah. Go ahead, Joe.
Yeah. I've been hearing the other day and it went fast. And my sound every once in a while cut out a little. But I thought that the 80,000 or 100,000 emails related to emails, if only, let's call them emails, that were available prior to probably Charlie's trial. And I don't think, it's often called the taint team. I don't remember what Florida calls it. That it was lawyers who went through all of them and decided they were potentially lawyer-client issues with Daniel Roshbaum. And Roshbaum knew about it, but the new lawyers were not informed. The state has never seen them either. And so they were saying, well, we've never, the defense was saying, we've never seen them. We've got to go through them. State can't say anything at all because they haven't seen them. I thought that's what the 80,000 or 100,000 related to. And I know that there are probably people in the chat who listened to that that hearing. I could be wrong, as I say, because that hearing went very quickly and it cut in and out, but that was what I thought they were talking about.
Yeah. We already had that question, COE. I know you're multitasking. Already has been addressed. Thank you. There's a question, forgive me because I can't remember from who. And Mike says that Donna handled her arrest like a pro. I mean, I guess there would be people who think otherwise, but maybe, I don't know. I would probably handle it a lot worse. A wiretap. Melissa, I'm not sure if you know the answer to this, but you're probably our best bet, having been a police officer, corrections officer. But someone was asking if there's a way to know that you've been wiretapped. I mean, the implication in the question was, well, Wendy's a lawyer. Does she have attorney friends who would let her know? But is there like a slight beep or anything that's a give on a wiretap that the Adelsons might be listening for or should have been listening for?
Well, that's kind of a reflection of the old ways where they were unable to often entirely preclude somebody from knowing. But I can't imagine today that any of those signs that it's being recorded would be evident there. But I also had I wonder about the number of emails that they're claiming, if there's a little bit of shenanigans going on. And my thought there is, for example, what I give students when they have a word count for an essay or an exam, they know how to play games with the word count. For example, taking out spaces between words and that kind of thing. So I just wonder whether the defense attorneys were simply trying to inflate kind of the number by how they're counting it. Could be maybe the same email chain was from several different accounts and they're double counting, triple counting. Anyway, so that just seems to be a sheer large number of emails. So I just wondered about that. I mean, in terms of what Tim Jansen is hearing as well, I agree that I don't think the prosecutors are talking to him directly about it. But as you all have mentioned, Tallahassee is a relatively small town. I think it was Metro Diner. Is that what you mentioned? So, just as the Adelsons kind of have forgotten that at times that they were on what could be recorded calls, is it could be sometimes as well prosecutors or police officers in the case may forget that they could be overheard. And when they're having conversations at lunch, for example, at the Metro Diner or other places. So that could be a way that information is being passed. Although, again, so I wanted to emphasize this, I don't think there's any prosecutorial misconduct here. It's just a small town and people are talking about their work and they forget that others can overhear them.
By the way, I always say, and you see it behind me, best guest, better community. I previously half jokingly talked about my daughter's desire to replace Simone Biles in the 2028 LA Olympics, which will likely happen. And then amazingly, that night, I get an email from someone who's actually on the LA Olympics committee. Why do I bring this up now? I was a reporter in New York. Everything in New York is difficult. No offense, Joe. You know I love New York, but it's a pain in you know what. And to get a press pass, a New York City press pass is like getting I don't know, whatever is winning the lottery ticket. How about that? So the COE's on it. I'm on it. A few other people are on it. But if there's anyone who is, I don't know, works within the Southern District of New York or knows somebody that can help us get a little nudge, I'd be very indebted. Survivingthesurvivor@gmail.com, survivingthesurvivor@gmail.com. Jeremy Mutz, this question that people are asking, they want to see Baby Levi, which I am not going to ask you to do. However, do you have another book out? I feel like you have another book out.
Well, I published 3 novels. 2 are crime novels. One is sort of a military thriller. I've published a novella, and I've published 7 short stories. So they're all on Amazon. The most recent one is a short story from just a few weeks ago. So I appreciate people asking about it. It's, such things I self-publish and trying to, finish another one here this year.
I thought I saw a new cover. All right. Well, there you go. Baby Yonatan about the youngest hostage is part of it. Is Jeremy the chicken raiser? Yes, he is. There was a best guest who brought on a pet chicken. You can never have enough pet chickens, especially with egg prices. So, Jeremy, you don't buy eggs, I take it.
Very rarely, because we generally get about 10 or 12 eggs every day. So
these chickens, man, they talk about rabbits, but these chickens produce a lot of eggs very quickly. So who knew? Joe Patuto, there was an interesting question with what we know now about new wiretaps and other investigation. What does this do, if anything, to a possible Wendi Adelson witness taking the stand at Donna's trial? Does the calculus change on that at all potentially?
I'm not sure what that questioner means. Does she mean, or he mean, a new witness based on the wiretaps? Or
No, I think is there any possibility that maybe the government has something potentially on Wendy? Now, this is all speculation.
sure, it's potential, but
But whereby they wouldn't call her for some reason now.
oh, well, I don't see that the two are related. They're going to ask Wendy the questions they've asked her in the past, and they're going to be very careful not to introduce new subjects or topics so that they're not widening the umbrella, the immunity umbrella that she's getting. If they bring in a new witness that has relevant evidence against Donna that they think they need, I guess there might be a potential. Well, no, that wouldn't be covered by any immunity that Wendy has. That witness can testify. They wouldn't bring a new witness to testify against Donna if the only evidence the witness had was against Wendy. It wouldn't be relevant to Donna's trial. So without knowing more in terms of what the questioner might be thinking, my answer is no. I don't think there's an issue.
There you go. Dr. Hamilton, this is your wheelhouse, having been a corrections officer. So we're also hearing about possible jailhouse informants. Now, we heard about this previously. Someone who had apparently or reportedly engaged in a conversation with Katie Magbanawa about, how this murder for hire was set up. But this sounds like it could be something completely different. I guess the bottom line question is, how much can you trust jailhouse informants, and why would that, I guess, have been put out there, not leaked out there, but literally put out there in a hearing if it wasn't something substantial? So do you think it is something substantial?
Very possibly. Jailhouse informants, they can be quite valuable, but then they always come with a risk that they're just not telling the truth and they want something else out of it. So they are often dealt with kid gloves, because usually the prosecution doesn't want to put on the stand somebody who's going to, well, they definitely don't want to put somebody in the stand who's going to commit perjury, but they're cognizant of somebody who's coming across as being less than credible, so not necessarily rising to the level of perjury per se, is that can really infect the jurors' thinking and questioning their other witnesses as well. So usually what happens is they will want to entertain the information, also do a little bit of background about the individual jailhouse informant, about their credibility, whether they've done this before. If it is useful information, that's great, but they do know that it will be subject to attack by the other. At the same time, is when you're talking about this kind of crime, which is hiring a hitman and you're dealing with murder and such, is you're going to have less than credible people probably involved. And that's something then the prosecution has to turn to and might be able proactively to use on their benefit about showing, look at the type of people that these are, the defendants are dealing with. They're dealing with the less than credible criminal connection with crimes, and that might be evidence that they are engaged in this because of who they're dealing with. So yes, lots of weighing and balancing the benefits of it, but with a lot of cases without jailhouse informants, there might not be sufficient evidence to get across the line. So the prosecution at least has some kind of obligation to at least entertain, is this credible evidence that is relevant to this particular case, and will and the jury will buy it, and then also not question the prosecution's other witnesses and credibility and their entire storyline.
Yeah, and Jeremy, is there a kind of a typical way that people get word from jailhouse informants? And by people, I mean you, the prosecutors. Is it usually that they reach out to you, or you, as the government, sniffing around the jail? By the way, Renita's watching from Mexico. She just saw Wendy cross her lawn. Wendy's all right; she's gone. No, that's all. That's a joke. But maybe Wendy will be there, and we'll have to ask Jeremy if they're keeping eyes on Wendy as they did with Donna. But yeah, the question I just posed, your thoughts?
I've seen it where inmates will sometimes write a letter to the prosecutor saying they have information and obviously wanting that taken into account where it comes to their own troubles. They may do that through their attorney. That's probably a safer way of doing that. That's probably the most typical way it would happen, that it would just be brought to the prosecutor's attention rather than that. But prosecutors in the past, and certainly in the old days, they would go interview cellmates. They would go interview people in a pod, say, what has this person been saying? And, you might get cooperation or you might not. It's definitely a risky thing to use such a witness, because we used to say in the state attorney's office, if you cast a play in hell, you can't expect angels for witnesses. And so it's the nature of the business. People involved in criminal activity are going to be criminals. And, there certainly is cases where there's honor among thieves, and people, have a degree of honor. They'll tell you the truth about their part. But then the defense on a case like that automatic credibility impeachment. Well, you're saying this because you're getting something in return, and you expect full well assistance out of your trouble. And so you're saying this against my client, and it can really backfire on the prosecution when you call somebody that they're not honest, they're not credible, and the jury sees right through that, and it kind of blows up in the prosecutor's face. Many prosecutors are wise to that. They're not going to call somebody in a strong case like this. They're not going to call somebody that risks their case. Other prosecutors may play it more fast and loose, and then it can backfire. But Donna herself was kind of calling, disclosing folks in the cell with her. And then that I feel like opens up the state to trying to dig deeper into what Donna's doing. Is she sending Zelle to people to get them to help her out? Is she sending, Cash App to people to get her to do that? So the other side of that coin is if the defense tries to use that kind of witness, the prosecutor can just hammer the credibility there that you're getting something out of this to come in and say A, B, and C about Donna.
Yeah. Well, Jeremy, you just brought it up, so let's go there, because one of the things that was brought up in court is that a search warrant was executed for Harvey Adelson's Zelle, and then someone sent me something showing me that Zelle only pertains to domestic transactions, so it can't be money that's put overseas into, let's say, a safe account. What do you make of that? What are they looking for? Are they looking for exactly kind of what you're talking about, which is maybe to keep someone quiet or pay someone off, possibly even within the Leon County Jail?
I think that's what they're looking at, and $250, $500 on somebody's canteen when they're in jail. That's a lot of money. That's a lot of candy bars. That's a lot of snacks. Or $500 to somebody's relative on the outside. That's a lot of money. And I think that could be something that the state's looking for. Whether or not Donna is engaged in that or not, I don't know. We'll see. But I think that's what they're looking for. And I think she is the kind of person that is going to try to push the envelope. She's kind of got nothing to lose. And her pattern, her personality is such that she doesn't feel the rules apply to her. So she may very well be engaging in that sort of thing.
Yeah. By the way, 5 usually see 5 during Adelson discussions. It's been a while. Wendy, it hasn't been that long, because I know you're here for the last one, I think. But Wendy committed perjury under oath on the stand when she said she did not drive down Trescott, when we know she drove all the way down to Dan's house where the tape and police were. So I'm sure Georgia obviously is well aware of that and dealing with that. Joe Pachuto, there's more of like a bit of a law school question slash, I guess common sense slash legal question, but it stems around the fact that you've got this investigation, and we heard Judge Everett talking about these motions are all sealed, but you have an active prosecution going on. How do you balance that, I guess, dichotomy of active investigation that you have to keep it confidential and closed, and an active prosecution where you've got to let the defense know some of what's happening? How is that balanced?
Well, whether something's under seal or not, that's a typical investigation moving to a prosecution. When you're investigating a case as the police or with the prosecutor, you're not calling the defense or the defense lawyers and saying, hey, tomorrow we're going to interview your brother about what he might know about the murder. It's always confidential. And there's a point at which, once the prosecution proceeds, once what we would say the Sixth Amendment attaches, once it's the adversarial process and it moves from investigation towards we're going to bring a case to trial, then discovery obligations trigger. By the time you get to trial, the defense is entitled to know anything that you know that has relevance to the case, and that you got to read broadly, because it's not up to the prosecution to decide what it thinks is relevant, because the defense may have a different view or may have other information when it's assessing relevance. So at the point at which that case is going, the defense is entitled to all of it. At the point at which you're building the case, the defense is not entitled to it, because you can't build a case. You can't do an investigation in public. Say, let's rent Yankee Stadium. Come watch who we're going to interview next. Listen to the wiretap we're getting. It has to be confidential. The issue with the protective orders is going to the kind of thing like a motion hearing or other things that typically might be done publicly, particularly in Florida, but where the defense is pushing for more protective orders, in part because they're claiming that we've got a jury pool that's going to be tainted beyond recovery, and where the judge is being very careful. But if and there may be things there that they're not relevant to the trial, that the defense and prosecution agree are not relevant to the trial, which may never be made public. It might be private information about somebody's, divorce or something that's not related to anything. So those things might never come to light. But everything else is going to be used at the trial or is going to be open later.
Yeah. Rachel D, often in the chat, bless Rob Adelson during all this. And it's an interesting point because I hate this word, but the collateral damage, the ripple effect of all this is extreme. And for those who don't know, Rob is estranged from the family, but there's talk of him being called here. Dr. Hamilton, just curious, not from a law school professor's perspective, but just a kind of human perspective. Now Ruth and Phil and Shelley Markel all have to wait for this trial, but so does a guy like Rob Adelson, who's he's not his family, but his family is accused of doing horrible things. His brother is a convicted killer now. What do you think this is like for him? Also, there's a good chance he's going to be called to testify in this trial. What do you think it is like for him dealing with all this?
Well, as a family member who has had close family involved in crime, it's a difficult position because you have a background with them, you have family connections, you might have blood or other family connections, and there's a tension there. Even though they're estranged, you still can't entirely get away from your family. Your family name, to the extent that it's a relatively uncommon name, is a little bit besmirched. So you continue to be drugged through this as well. And then it's not fun for most people to be called in front of trial and to testify. And then when you're talking about testifying involving your own family, that's difficult. At the same time, he may have been very close to Dan as well. So it could be that he's feeling that loss. But this trial is definitely affecting him. And just kind of an overall comment is, we like to think about criminal law as doing justice for the victims, but that actually is not its primary purpose. It's to uphold the criminal law and to represent the state and the state's interests, and not really the victim's interests or the victim's family here, their interests. So it's, while it often has that benefit, that's not the purpose of prosecuting, is they're not representing the clients directly or even indirectly.
That's a very interesting point. I think that's tough for people to wrap their head around, but it's interesting. President Gerard here, Jeremy, back with some clarification. Thank you, Jeremy, for your previous answer. I was asking if there's information gained by Rashbaum in any of these new emails that is crucial to the defense, then aren't we back to conflict again? So that's interesting. If there's something, I guess, that Dan Rashbaum brings to the table, and now he's been conflicted out, what do you do?
I don't think it would be a problem for the current defense team. I think if they wanted to call Rashbaum as a witness or something like that, I don't think it conflicts with them representing Donna. In that standpoint, the conflict would arise if Mr. Rashbaum is actively practicing law representing Donna in such a way that there's a conflict with his representation of Charlie. I don't know that either side would want to have him as a witness in this case, just to stay completely away from it. But even worst case scenario, if he's a witness, I don't think that would trigger any conflict with Mr. Zellman or Miss Fulford.
Just looking at some of my notes here. Jeremy, I just want to go back to you. And this is a part of the story. This is not body shaming at all. And Donna herself said that she has put on a third of her body weight. She looks much different. She's eating mainly carbs. And I remember John Singer, who, by the way, I've been speaking to, and I'm going to hang with when I go up to Diddy, and he's going to come back on for the trial. John just happens to be exceptionally busy, which I get. So her physical appearance, she said, again, she put on a third of her body weight. And there's people I'm seeing in the chat now saying what John Singer said is that she might not make it much longer. I don't think she's in that kind of bad shape right now, because she was a pretty spry, then 73-year-old, I guess. But curious what you make of her appearance. She looks worn, looks tired. The hair dye is out. The pounds have been packed on. Is that typical? In terms of an inmate who's been, I think the COE said she's been behind bars now for 543 days. Is that typical, or does she look better or worse than what I guess you would expect at this point?
It's fairly typical. I've been in prisons, jails many times, talking to clients, interviewing witnesses in various capacities. And you don't have the physical activity that a person that's physically active on the outside is going to have. They're going to deteriorate. You're not going to have the food that you want. It's stressful. So you sit in a cell, maybe you think about your case and you eat, and you're not physically active. But I don't see that there's really a health concern, a serious health concern for her. But it's not pleasant. She'd be much healthier at home. That's obvious. But I don't see anything that crosses the line of improper care or anything like that, or such that would affect her ability to constitutionally defend and assist in her own defense. But it's not pleasant. And again, she's the kind of personality that she's going to push that to the forefront, that I'm being mistreated. I should be able to get out. Look what they're doing to me. And that's a lot of it, her personality. But I have many clients that gain weight when they're in jail awaiting trial. And she really doesn't look bad to me, and just as an outsider. But I mean, obviously, if I'm in her shoes, I'm not getting to go to a salon. I'm not getting to use makeup. I'm not getting to use the face creams that I want to use. And that's unfortunately the nature of jail. If you don't like the treatment, then don't do the crime, I think has been said.
Yeah.
At one point.
Yeah, that's for sure. And she doesn't have all the accoutrements that you would have on the outside. This is interesting too. I think it was True Lifestyles who kind of tracks Donna's prison logs. And apparently, Jeremy, I'm going to come back to you on this as well. She's refused blood work. One of the issues a couple of hearings ago was that jail's too tough on her. The mattress isn't comfortable. She's not feeling great. Is it possible? The speculation was, I guess, that if the blood work shows she's okay, she's refusing the blood work, so she can still make the case, hey, I don't feel well, I'm not doing well. How do you bridge that? How do you, if you're the jail and you want to take her blood work and she says no and then says I don't feel well, what are the repercussions there?
And that could get complex. Constitutionally, you have to provide a minimal level of appropriate care. And there are, lawsuits that challenge that, in state and federal court, constantly in the state of Florida. But it's a constitutionally minimal level of care. It may not be the care I choose for myself. Again, kind of like the care and healthcare and food and diet and exercise that she would choose for herself on the outside is equally applicable to the medical care on the inside. I don't get to dictate the level of medical care of my choosing when I'm in custody, but they have to treat her if she injures herself. If she's diabetic, they have to provide adequate care and testing. If she's refusing something, then maybe she is trying to write a grievance at some point or do something with that at some point, saying maybe the last time they drew blood for me, they injured me, they bruised me. It may be something of that nature that she's trying to set up, or it may be she feels she may throw her hands up and say, well, they're not going to really give me the care I want. I'm not going to just keep getting blood draws to monitor this. I'm basically fine. It's hard to guess where she's going with that. But then if you're on the jail standpoint, the provider, the medical providers there, they have some duties to administer care, whether she agrees to it or not. If they're not going to just let her go into a diabetic coma or something because she doesn't want a blood draw, they're going to do what they have to do to keep her safe. But it's not the level of care that she would get with her primary care physician if she's outside and able to avail herself of that.
Yeah. Sherry Douglas in the comments, I want to get to this one, so I'm leaving it up, but she says they said she was getting to see a doctor or nurse within 3 days. It takes me 2 months to get into a doctor or dentist. Try going to see a dermatologist in Florida, in South Florida. It's impossible. I have to wait, 3 or 4 months. So it's a good point there. Ida Shaw, JD, a loyal STS Nationer. For Professor Joe, is there no issue either calling Rashbaum regarding Donna's trip to Vietnam, her claim in court, and his claim on STS? What do you say, Joe?
Yeah, well, to the extent his conversations with Donna are covered by lawyer-client privilege, the state certainly can't call him and make him testify. But Donna, the privilege belongs to the client, not to the lawyer. So Donna can waive the privilege and call him. And there was some, Ida's right, there was some information at that hearing the other day with regard to those 80,000 or 100,000 texts that the taint team decided were potentially lawyer-client, that there might be something in there. This is from the defense side. Zellman said, we might want to use it. And he said something along the lines of, we may want to say that Donna's flight to Vietnam was not fleeing or consciousness of guilt. It was done on advice of lawyer. Now, I think there's a lot of evidence out there, some of it out of Donna's own mouth, that would make that particular defense claim pretty difficult to maintain. But to the extent they want to do it, she would waive the privilege, and then they would ask Rashbaum, what did you tell her? Now, if they depose him and he says, I told her, essentially, Joel, what he said on your show, or what Donna said he told her in that wiretap, which is they talked to him and he said, you might get away. That doesn't sound like advice from lawyer. And what he said, Joel, on your show was she wasn't under arrest. She wasn't charged. She was perfectly free to leave. I just don't see how they're going to be able to use it. But as long as Donna waives, to get back to Ida's question, as long as Donna waives, he can testify.
Yeah, that would be fascinating, wouldn't it? Sherry B here, back to Jeremy Mutz here. I don't understand the 100,000 emails. How is it that this defense is not being compromised by seeing these emails from the last defense. Again, this issue of the conflict. Another question or two, and then we'll get some final thoughts, everybody.
Well, even let's take worst case scenario. These are emails between Mr. Rashbaum and Donna. The content of that doesn't create a conflict for a new attorney reading those necessarily. It's just an email communication. And those may be sprinkled in amongst other things that are just purely factual. Donna, lamenting to a relative or a friend that all these things are going on, and they're having to sell things, get things in order so they can go to Vietnam. So there may be a little bit of attorney-client stuff in there, and the rest not. But that wouldn't necessarily taint or make a conflict for the new attorneys.
This is a funny comment. Joe's computer has a cataract. No E in Joe, but I'm just a stickler for spelling. Jeremy Mutz, two other quick questions, and we'll get final thoughts. Are you using AI in with your discovery these days?
I'm not. I mean, I do criminal defense, so the discovery in my cases, for the most part, are not voluminous, and I'm kind of a slow adopter of AI, but it can certainly. You almost have to use it if you're doing civil cases, family law, or defending a case like this. I would say it's almost malpractice not to use it.
Yeah. Well, baby Levi, when he's practicing law in 30 years, he will look back, he will watch this episode, and he will know that his father was an absolute Tyrannosaurus Rex, who by that time they'll have law school chips implanted in your brain, and he won't even have to go to law school. So we're missing out, Jeremy Mutz. Your kid's not going to have to go to law school, but he will be a practicing attorney one day, and he'll be able to stay home and raise chickens too. So be doing a lot of stuff, multitasking. Anyway, last question for you, Jeremy, and then we'll get final thoughts, I promise. So John Sawicki, a friend of the show, friend of mine, great guy. He is like Dr. Hamilton, a former police officer turned attorney who now has a digital forensics firm. And it's not 1,000% confirmed, but I reached out to John, and he basically very nicely said no comment. It appears that he is working for Donna's defense team. What's he doing? What do you think he's doing there?
Well, I know one angle would be potentially to challenge some of the cell tower data parameters, because that was a part of the state's proof in terms of putting Donna near Charlie's apartment or things like that, the proximity. And so he may be challenging a different interpretation of that data from the cell towers. That may be part of it. Just off the top of my head, that's, I think, something that would be relevant to what he's an expert in.
Well, Dr. Melissa Hamilton, she is a former, as you heard several times, corrections officer, a police officer. Her own family was involved in violent crime that she dealt with, so she's very tapped into this sort of dynamic. And now she is a dynamic law professor at the University of Surrey in the UK. And your final thoughts here, Dr. Hamilton, sunny in San Clemente, beautiful city in California, by the way. Do we know for sure that Donna was being watched after Charlie's trial, or did someone just tip off the FBI? Whatever it was, they did great work there. I guess the obvious question is, do you think, Dr. Hamilton, with your experience in law enforcement, that they do have eyes considering this new investigation? Do they have eyes on Harvey and Wendy now? Wendy's said to have moved to Texas. So I guess that's my question. Do they have eyes? And your final thoughts here today.
It very likely they did, because what they set up was the risk that they were going to flee. So they've got you've got two people who are heavily invested in that trial, and the outcome of the trial goes against Charlie. They're in the sights of the prosecution and the police, and most importantly, they have sufficient money to have done it. So I would not be surprised that they were on alert for watching for movements that those two were about to flee. And just one other comment about Daniel Rashbaum is, I also think in context is he did not give them advice to leave, that they were asking him and he said, well, you could, but I doubt he affirmatively said, I suggest my counsel is for you to leave the country. in context does not seem that even he would stoop to that kind of level.
Yeah, Dan's actually a pretty smart guy, and I guess time is going to tell how all of that played out. But my inclination is to lean toward Dr. Hamilton. Jeremy Mutz, friend of mine, friend of the show, new father and author. What else can you say about the guy? He has his own chickens, so he can hatch his own eggs. So he doesn't have to go to traders and be told that they're sold out and or $25 a dozen. There's price gouging going on with these eggs everywhere. What I found out, which is interesting, I did a show last night on Diddy, and I asked criminal defense attorney how much Diddy is paying for this defense. And the answer was a large part of his fortune, which Jeremy Mutz, that made me think criminal defense attorneys, they can't get in trouble for price gouging. In other words, if I came to you, Jeremy Mutz, and I said, I need help, you could charge me $1 bazillion. You could charge me Warren Buffett's entire net worth, and you could get away with it. It's a pretty good career. So, Jeremy, I hope you get some very uber wealthy clients. I would not be one of them, but it would be great for you. Now that I've rambled on about nothing, your final thoughts on all this, Jeremy. At the very least, it seems like the stakes have been raised. It looks like there are other people potentially in the SAO's crosshairs. Do you agree?
I do. Oftentimes defendants end up giving the prosecution the strongest evidence that's going to be used against them when they flee their consciousness of guilt, if they make comments, and if they try to influence other witnesses. And it's often worse than the circumstantial case that existed against them to begin with. In the months leading up to this, I predicted the state would keep working on this and get more evidence. I predicted there would be new evidence coming out in the digital world, and that's coming to fruition. So I'm not surprised by it. And they're going to keep working on it. If Donna were smart, she would go radio silent. If Harvey and anybody else that's in communication with her, but I don't really see that happening, the personalities that we're dealing with. But, would they say even the fish, if he kept his mouth shut, wouldn't get caught? And I think that's kind of what's going on.
Yeah, that's a really interesting point. Ida Shaw making another salient point. I have no idea what you said, Joel, and I was listening carefully. It's usually what the COE says to me. Jared Ross is in the house. He helps run Justice for Dan Markel. Chewy Boy letting me know that I do ramble on, and someone else saying it's excellent because we're just talking about this is what happens at 12:30 shows when I'm about to take my boy to a Dodgers game. I just start rambling. Joe Patuto, you are the professor emerita, University of Nebraska Law. She teaches us all about the law every single day when she's on this show, which is not every single day, but almost every single day. Joe Patuto, I don't know what's next for this case. This is a long, windy road. We've got a hearing on Friday. But what are you like? I don't know. What could be the next big thing here prior to the trial itself, now scheduled for August 19th?
Well, I guess my imagination is not good enough to predict a new sort of, I wouldn't call it a bombshell, but something big. I think everything that they have right now, we know. We don't know what it is, but we know where they're going. Whether an investigation will find more, I do not know. What I would like to be ahead for this case is a set trial date that doesn't get moved again. That I would love. And I would say amen to what Jeremy said, because if you look at Donna, when he said that defendants often provide the best evidence, if you look at Donna's case, she provided the evidence of flight, which is going to be consciousness of guilt. She chatted like crazy with Charlie, and that led to the wiretap, and that led to all kinds of other evidence that they have. It looks like potentially that she may be involved in trying to get someone in the jail to support her story. And if that's true, that's what led to the investigation and what may be wiretaps of Harvey and the Zelle and everything else. And I don't even have everything that she did. Oh, and her reaction to the undercover sting was so incredible. You take all that out and ask yourself whether you could have prosecuted Donna successfully. And she did all that to herself, and she's continuing to do it. She is a chatty Cathy that cannot keep her mouth shut. And even with all the evidence that everything she says has hurt, she continues to talk.
Very well said. This Friday, 9 a.m., Donna is back via Zoom in a Leon County courthouse. We'll bring it to you live, followed by, I think, Phil and Scott together for the first time in a very long time. Tomorrow night, we're doing a show on Brian Koberger, as that case is getting increasingly more interesting as we get closer to trial. Huge thanks to the law professor Joe Patuto, Jeremy Mutz, the author, criminal defense attorney, former prosecutor, and the former police officer, corrections officer, and law professor, Dr. Melissa Hamilton. Love this panel. We will bring them back. And as always, it is justice for Dan Markel. If you want to watch me at the Dodgers game, which is probably the last thing on earth you'd ever want to do, not live, but I will be putting up pictures. My kid's cute, so that helps. Instagram, Surviving the Survivor. You can follow me on Twitter at Podcast STS. And I saw someone say their merchandise is on the way. The COE spent a lot of time putting together a, I guess, more female-friendly STS merch store, because we're getting some heat about some of the merch. So check it out. I think there's a link on YouTube. Love you, America. Love you, Jersey. Love you, Tallahassee, where Jeremy Mutz is. And, of course, the United Kingdom, the Republic of Ireland, Australia, Ohio. People yell at me for never acknowledging Ohio and other random states around the United States. See you tomorrow.